Thank you, everyone. If we could start, yes. Welcome to all of you. It is a distinct pleasure and an honor to have this event take place at the American University of Armenia. This is a collaboration between the Institute of Sociology, Politics and Law of the National Academy of Sciences. The idea came about, Mr. David Acopian approached me and said, would it be interesting to organize this, co-organize this? And of course, we always want discussions of this nature taking place in the country. And as you will see in today's agenda, we also want to explore possibilities of pushing these kinds of discussions to larger forums. Citizen assembly, citizen participation, and we'll have an example of the Irish Citizen Assembly James Souter will present, and that is considered one of the more successful cases of citizen participation in constitutional reforms. Just as a way of introduction, this is a very timely discourse in Armenia. A handful of nations have environmental responsibilities included in their constitutions before the 1970s. But since then, the number has grown, the first country being Switzerland in 1971 that incorporated environmental rights into their constitution. According to UNEP, United Nations Environment Program, a report they published a couple of years ago, Environmental Rule of Law, First Global Report. As of 2017, 150 countries have enshrined environmental rights and responsibilities into their constitution. And many of them and others who do not have it in their constitution have framework laws on the environment. And 164 countries have cabinet level bodies responsible for protection. This kind of hints to the distinction between environmental rights, responsibilities, and the institutional capacity to implement those, because I think that's where most nations fail in the implementation. So Armenia is unique in a sense that we had environmental rights and obligations enshrined in our constitution in the previous version, and in the latest iteration, it was taken out. I think as there's the constitutional reform process is underway, we need to revisit and see if it makes sense for us to include it back in, and in what way we should include it back in. There are 5 main categories of constitutional provisions, government's responsibilities, deep environmental rights and responsibilities, procedural, like what the Aarhus Convention says about, access to justice, access to information, things like that, individuals' responsibility, and then, of course, generic governance of hazardous material movements. So these are all components that can be discussed in the context of constitutional reform. So today we have a very set of speakers. Apparently, the Netherlands talk about Dublin's diversity, and I came to know citizen assemblies deeply as part of a new funded project. We're still it's still ongoing. Heritia, which it was a licensing project led by the University of Dublin, and Maria Babramian, who I believe is with us. She brought really interesting ideas to Armenia through this project. We became a partner in this large consortium. And one of the things we're going to try is a citizen assembly on a different topic, but the citizen assembly idea could be interesting to explore for Armenia. It's definitely. So now it is my pleasure to invite Mr. Davian, Director of the Institute of Philosophy, Sociology, and Law at the National Academy of Sciences of Armenia, for his opening remarks.
Thank you very much, and your excellencies, your colleagues, participants, ladies and gentlemen. It's my pleasure to be here with us today, and this is our first visit to AUA, my new position, and in this respect, I would like to thank the host organization, especially Mr. Acopian for the initiation of this event and for recording the topic regarding environmental rights and the constitutional reforms in Armenia. I will just give a short description, main activities that our institution is doing since the foundations. And this is a National Academy Science Institution, and we are conducting research in four fundamental directions such as philosophy, sociology, law, and political science. And our main 6 departments now are focused on relevant areas concerning the theory and history of Armenian philosophy and aesthetics, logic, as well as social and political transformations in post-Soviet space. And another traditional research field that we are focused on is the law, especially the law and particularly the theory and history of law in Armenia. Theoretical foundations and phenomenological aspects of right theories. And along with all these topics now, we are working on the initiation and the exploration of new ones that are related to international comparative law and as well as environmental role. We know that the environment has a huge role for our well-being, or the well-being of our society. It has a huge impact on our life quality, and it plays a role, an important role for equality of human rights. And in this respect, philosophical, sociological, legal, and even political insights, and as well as the comprehension of the environment is needed, respected from an academic perspective. And we hope that we could be integrated in this topic. And I am completely convinced that this event will open up new horizons, will give new opportunities for our further collaboration, for our critical collaboration. And I would like to welcome all participants, and let me end up with words of Michel de Montaigne. Let us permit nature to have her way, because she understands her business better than we do. Thank you.
Thank you very much, Mr. Acopian. So now it is our pleasure to invite Deputy Minister of Environment, Ms. Gabrielian, who will talk about Ministry of Environment's position on environmental rights. And welcome us.
Thank you very much. Let me also say some words of thanks to this organization and to this. Ես իրոք շնորհակալ եմ այս հանդիպման համար նախագծիչներին եւ հետո շատ շնորհակալ եմ ինձ համար։ Ես կարծում եմ սա շատ կարևոր կամուրջ է գիտական աշխարհի եւ կառավարության գործընկերության համար, որովհետեւ մենք բոլորը գտնվում ենք այսօր պատկանակայքում, որտեղ որևէ տար առողջություն չի գալու։ Եվ այն հարցը, որը դուք այսօր բարձրաձայնում եք, ինձ համար կարևորագույններից մեկն է, ինչու արդեն ասացիք եւ իմ նախորդ բանախոսներն ասացին, որ բնապահպանական օրակարգը, բնապահպանությունը սահմանադրական մակարդակով հնչեցվող օրակարգ է, չէ՞, խուսափում բնապահպանական իրավունք, ասելով կամ բնապահպանության շրջանակի պահպանություն, որտեղ ես զգում եմ ներքուս, չլինելով իրավաբան, ես տնտեսագետ եմ, բայց իմաց որում եմ իրավագիտություն, որտեղ պետք է դեպքում ասացի, եւ ես շատ համաձայն եմ, որ այնուամենայնիվ բնությունը ավելի լավ դիտի իր օրենքները, սակայն մենք դեպ մասնագետներ եւ դեպքում ենք ինչ-որ ուղղվածություն, պարփակվում ենք այդ գաղափարների մեջ, այսինքն ես իբրև տնտեսագետ, դուք իբրև իրավաբան, եւ այս 21-րդ դարաշրջանը ես կարծում եմ, որ խառը մասնագիտությունների դարաշրջան է, որտեղ այլևս տեղաթուրվել են այն սահմանները, թե որտեղ է ավարտվում տնտեսագիտությունը եւ որտեղ է սկսվում իրավագիտությունը, բժշկությունը, բնապահպանությունը եւ բոլոր մասնագիտությունները։ Եվ եթե մենք ուզում ենք դիմակայել այդ մրցակցության մեջ, իսկ սա մրցակցություն է, եւ 21-րդ դարը կանաչ մրցակցություն է, մենք պետք է սկսենք խոսել բնապահպանական անվտանգության մասին։ Այսինքն ինձ համար բնապահպանական անվտանգությունը վեր է շրջակա միջավայրի պահպանության, բնապահպանական իրավունքից եւ ցանկացած այլ իրավական տարրից, որը առնչվում է շրջակա միջավայրի բոլոր ուղղություններին։ Եվ ես որպես շրջակա միջավայրի նախարարության եւ կառավարության այդ գերատեսչության ներկայացուցիչ բազմից դարարել եմ, որ 2023 թվականը շրջակա միջավայրի նախարարության համար որպես ինստիտուտ համակարգի ստեղծման տարի պետք է լինի եւ պետք է սկսենք բնականաբար իրավաստեղծ գործունեությունից, որովհետեւ ունենալով մեծ շրջանակ եւ Հայաստանի Հանրապետության 20%-ից ավելը ենթարկվում է կառավարման առումով այդ ինստիտուտին, շրջակա միջավայրի նախարարությանը, մենք այսօր ձեր հետ շրջանակային փաստաթղթի լուրջ խնդիր ունենք։ Երբ որ դուք խոսում եք շրջակա միջավայրի իրավունքի եւ օրենքի մասին, մենք խոսում ենք բնապահպան շրջակա միջավայրի օրենսգրքի բացակայության մասին, որը իր մեջ կարող է ներառել այն բոլոր գլոբալ ուղղությունները, ջրային օրենսդրությունը եւ ջրային դիվանագիտությունը, որը մեզ համար հաջորդ տարվա կարևորագույն հարցերից մեկն է եւ մենք դրանք որպես առաջնային ենք դիտարկում։ Հանքարդյունաբերություն, պատասխանատու հանքարդյունաբերությունը, որը ըստ էության մեր համար պետք է դրվի որպես շրջակա միջավայրի օրենսդրության բաղադրիչներից մեկը։ Կանաչ տնտեսության օրակարգը, որը իր մեջ պետք է ներառի շրջանակաձև տնտեսությունը եւ դրանից բխող կանաչ տաքսերի, կանաչ բոնդերի, կանաչ ֆինանսական գործիքների, կլիմայական օրակարգի ներառումը, ֆիսկալ ռիսկերի հետ կապված մեր գործողությունները, որ մենք այսօր ֆինանսների նախարարության հետ տանում ենք, որտեղ եթե Հայաստանի Հանրապետությունը գլոբալ աշխարհում հայտ է ներկայացնել պարտավորությունների, իսկ մենք ներկայացնում ենք եւ Փարիզյան համաձայնագրով դեպի կոնվենցիա եւ շուրջ 20 այլ կոնվենցիաներով, ապա մենք պետք է հասկանանք որտեղ է մեր տեղը ֆինանսական իրույթ, որովհետեւ այսօր այդ տեղը անպարզ է եւ երբ որ մենք խոսում ենք ֆիսկալ ռիսկերի մասին, ապա Հայաստանի Հանրապետությունը այսօր չի կարող հստակ ասել կանաչ օրակարգում որտեղ է մեր հնարավորությունները ֆինանսական, որի մեջ մենք կարող ենք շարունակել գործել, որովհետեւ կանաչ օրակարգը թանկ օրակարգ է, որտեղ մենք մարդկանց ներգործությունը բնության վրա հատել է այն սահմանը, որ այլևս առանց լրացուցիչ ներդրումների մենք կարող ենք դառնալ, որից հետո իմ նախորդ բանախոսի պես թողնենք պիտի ինչ-որ մի կետի բերենք այդ բնությունը, որից հետո կարողանանք դա թողնել։ Չարշահելով ձեր համբերությունը, ասեմ, որ եւս մեկ անգամ environmental security is the most important part for the next year for Republic of Armenia and for Ministry of Environment. For us, it is now the priority to have environmental code, and under this environmental code to put the most important fields for Armenia. This is responsible mining, green economy, climate agenda, climate resilient adaptation and mitigation, possibility of water use, the main points of water diplomacy, because this was the main topic for us to discuss. This is Aarhus Convention, that. But at the end of my speech, I would like to say that we all need you, because we are the one who are coming today, that we are not important. System is more important than we. I am, as a representative of government, telling that Gane Gabrielian is nothing. System is everything. We need to build system to give it to our generation, to put them in the system, working system, because we don't want corruption. We don't want any more environmental damages. We just want to build the system. If it is possible with your help, thank you very much. If no, we will do it by ourselves. Thank you very much.
Thank you very much, Ms. Gabrielian. Look forward to all the different activities that the ministry is doing, and we're also partnering with you for the directions. Now it is my pleasure to invite His Excellency Mr. Patrick Svensson to give a few opening remarks. Sweden is a good friend of Armenia's environment and the world's environment, and we look forward to your thoughts.
Good afternoon, everyone. Dear Alan, the Deputy Minister, dear colleagues, dear friends. It's a pleasure to be back here at AUA. It's always an energizing opportunity to visit AUA, and actually today I'm coming straight from the nature. Actually, I'm coming from Vedi, where we were celebrating the European Heritage Days together with Armenian partners and European colleagues there. And students from Vedi. We were just by the Kosovo State Forest Reserve. We said no to plastic and we planted trees. So I thought that was a very fitting introduction to coming over here to AUA. So let me just say a few words from my side here. Well, first of all, I would like to thank AUA and the Acopian Center, not the least, as well as the Minister of Environment for being partners together when it comes to the environment and climate field. We have a 4-year commitment in a joint program. And as Alan said, Sweden is committed to trying to be of some support when it comes to the nature and the environment field in Armenia through our development cooperation work. Now, the Paris Agreement, of course, states that climate change is a common concern for humankind, and that respect for human rights is a requirement when acting on climate change, including the principle of equality and just transition. And the European Green Deal also speaks about something called just transition as a key tool to ensure that the transition towards a climate neutral economy happens in a fair way, leaving no one behind. For me, as a representative of the Swedish government, I can really try to emphasize that we try to put the environment and climate change among the top priorities wherever we work within our development cooperation. Natural capital like natural resources, ecosystems, ecosystem services, and climate form the basis for human existence and activity. People living in poverty are often directly dependent on natural resources and biodiversity, such as forests, land, and water. And the right to health, the right to livelihood, rights to water, and sanitation. These are all fundamental rights. Sweden's development cooperation is guided by a human rights-based approach. And according to the application of such a human rights-based approach, this involves, among other things, assessing how each development contribution will help realize the human rights as laid down in the UN Human Rights Conventions, and also how to ensure that it will do no harm to the livelihood strategies of the poor. Now, I think we often find that a root cause to environmental problems we all face are weak institutions. Was also mentioned here earlier, the importance of institutional capacity building. Sometimes there is ineffective environmental legislation, unclear accountability, poor transparency, and also a lack of public access and participation. For us, by applying the human rights-based approach when supporting the strengthening of institutions and governance, we believe that we can actively promote the work to protect the environment and to promote people's right to healthy ecosystems and natural resources. Another way to contribute to environmental protection is to provide effective mechanisms for defenders of biodiversity and ecosystems, either to individuals or collectively to local communities living in areas under exploitation by others. We can support them to exercise their civil and political rights without fear of persecution. Certain human rights, especially those laid down in the Aarhus Convention, just mentioned earlier by the Deputy Minister, for example, access to information, participation in decision-making, and access to justice in environmental matters are essential to good environmental decision-making. Therefore, we as a country, Sweden, we try to link all environmental contributions to civil society and always to have a participatory involvement by civil society. Dear friends, in conclusion, let me just say that overcoming the threats of climate change and environmental deterioration is one of the absolute biggest challenges facing humanity today. And of course, we all need to work together as governments, academia, research institutions, civil society, and the private sector, not the least, to succeed. And integrating the basic human rights will make our efforts so much more stronger. So without any further ado, thank you for your attention. You have great experts here. I've seen the panel agenda for the rest of the day, and I'm sure you will have an excellent and interesting exchange here this afternoon. And I wish you, therefore, a very successful event. Thank you so much for inviting me here today. Thank you.
Thank you very much, Mr. Svensson. Part of the reason we've invited our international friends to be part of this because Armenia cannot do this alone. We are part of a we're a member of the global community, and we have to always work together with other nations, countries, and make sure we tap into the know-how and expertise and wisdom of those who have tried to go this path. So with that, it's my pleasure to invite Mr. Paul Morris, Deputy Head of Mission at the British Embassy in Armenia, for a few thoughts on the British perspective on this.
Thank you very much. And I'm really pleased to be here as well. I'm finding it really interesting listening to all the speakers who have come forward today, but also the conversations we've had beforehand have been really interesting today. The UK is really concerned that climate change and environmental degradation have implications for human rights in Armenia. It can pose a risk to life and well-being of individuals and communities, disproportionately affect the marginalized, vulnerable, including women and girls, and those living in poverty. This year has seen a wave of environmental crises around the world, from heat waves, catastrophic flooding. The human impact of each disaster has made the link between human rights and environment clearer than ever. This summer, the international community collectively acknowledged this when the UN General Assembly approved a historic resolution recognizing a clean, healthy, and sustainable environment as a human right. Following this important declaration, it now calls to individual states to ensure that this right becomes a reality for everyone. This means enshrining its international law where it doesn't already exist, incorporate it into international human rights treaties, and ensuring full implementation of international, national, and local levels. We welcome efforts made by the Armenian academic and research community, the government, and other stakeholders to institutionalize protection for the environment and create environmental framework for constitutional reforms. The UK has a strong record of addressing the linkages between human rights and climate change. We supported the first UN resolution on human rights, climate change, back in 2008. And in 2015, we signed Geneva Pledge for Human Rights in Climate Action. We're committed to implementing the Gender Action Plan agreed at COP25 and co-sponsored the UN resolution. We'll continue to call on states to fulfill their human rights obligations by taking action to combat climate change. Our commitment to tackling climate change is resolute. We were proud to host the COP26 last year, when we continue to work with all of the parties and others to achieve an ambitious shared outcome and demonstrate the UK's ongoing leadership and climate commitment to supporting vulnerable countries. I'll provide some highlights of some of the things that we've achieved over the past few years. So we supported 95 million people to better adapt to the effects of climate change, provided 58 million people and 220 social institutions with improved access to clean energy, avoided 410,000 hectares of deforestation, reduced or avoided 68 million tons of greenhouse gas emissions. We know there's still a lot to do, but I'd like to thank the National Academy of Sciences and Acopian Center for the Environment and the American University of Armenia for your constructive and positive work. And I look forward to hearing about some of the discussion this afternoon. Thank you.
So now we're jumping in. Dear David, please, and he will give us some provocative thoughts to discuss and to ponder over. So please.
Բարև ձեզ։ Շնորհակալություն, որ եկել եք, նաև ողջունում եմ մեզ լսողներին։ Իդեպ այսօր քիչ առաջ ինտերվյու եւ ես հատկապես ասացի, որ մեզ համար շատ կարևոր է, որ սա իրականում ինչպես ասում են, իմացողի, ցանկացողի եւ կապկացողի, այսինքն երեք այդ գիտություն, քաղաքասարակություն, մասնավոր սեկտոր եւ նաեւ գործադիր իշխանություն ծրագրում ենք փոխնախարարի համատեղ ընդհանուր քննարկում է եւ այս համատեքստում այս քննարկումների կազմակերպումը եւ նաեւ երևի թե դա ինձ դարձեց, որ ես նաեւ հիշեցի ներդրումների ալտերնատիվ փոխեմ նաեւ այդ դիտենալու գործերը ասեմ, որ ավելի ստատիստիկի մոտեցումները, որ կներկայացնեն ազնագողովին եւ խորհրդին։ Շատ հակիրճ ուրեմն միայն սահմանադրական, միայն բնապահպանական օրակարգ երևի բավարար է, որպեսզի հիմնավորվի այդ սահմանադրական բարեփոխումների անհրաժեշտությունը։ Մինչև 2015 թվականը շատ հակիրճ նշեմ, մենք նախկին սահմանադրության մեջ մի քանի դեպքեր։ Առաջին գլխում պետությունը խթանում է շրջակա միջավայրի պահպանությունը, բարելավումը եւ վերականգնումը։ Բնական պաշարների ողջամիտ օգտագործումը ղեկավարվելով կայուն զարգացման, սկզբունքով եւ հաշվի առնելով պատասխանատվության, ապագա սերունդների առջեւ։ Սա իդեպ միակ դրույթն է, որ մենք ունենք այսօր 2015 թվականի սահմանադրության մեջ։ Իհարկե, ունենք երկու կարևորագույն սկզբունք, որի մասին մենք ես կխոսեմ, կայուն զարգացման սկզբունք եւ պատասխանատվություն ապագա սերունդների առջեւ։ Նախկին խմբագրության մեջ մենք ունենք 3 հիմնական դրույթ։ Առաջինը՝ ի տարբերություն հիմա, որտեղ պետությունը խթանում է, նախկինում ասում է պետությունը ապահովում է շրջակա միջավայրի պահպանությունը եւ վերականգնումը, բնական պաշարների ողջամիտ օգտագործումը։ Մենք ունենք սկզբունք, մենք ունենք իբրև հիմնական իրավունք, որ յուրաքանչյուր ոք իրավունք ունի ապրելու իր առողջությանը եւ բարեկեցությանը նպաստող շրջակա միջավայրում։ Այսօր այս հիմնական իրավունքը չի նախատեսված սահմանադրության մեջ։ Եվ նախկին խմբագրության մեջ կար դրույթ, որ սեփականության իրավունքի իրականացումը չպետք է վնաս պատճառի շրջակա միջավայրին։ Այս դրույթը եւս դուրս է եկել սահմանադրությունից։ Ինչպես նշեցի, գործող սահմանադրության միայն ունենք այս մի հոդվածը։ Մի փոքր պատմական ակնարկ, առաջին անգամ Յելոստոնի ազգային պարկով 1872 թվականին սկիզբ դրվեց ազգային պարկերի ստեղծման այդ միտումը, ռեժիմը եւ որոշվեց էսթետիկ նպատակներով, նաև բնական ցիկլերի հաջորդականությունը ապահովելու նպատակով ստեղծել ազգային պարկեր։ Եվ մոտ 100 տարի այդ ոլորտի կարգավորումը գնացել է այդ ուղղությամբ։ Կային բազմաթիվ ռեժիմներ, ազգային պարկեր, արտելոցներ, հատուկ պահպանվող տարածքներ եւ այլն։ Այնուհետև առաջին փուլը 1972 թվական այդ մակի ռեֆերանս եղավ եւ ընդունվեց Ստոկհոլմի հռչակագիրը, որտեղ առաջին անգամ սահմանվեց արդեն իբրև հիմնական իրավունք, ապրելու այնպիսի միջավայրում, բջջական միջավայրում, ինչը կապահովի անձին արժանապատիվ եւ բարեկեցիկ կյանք։ Եվ սահմանվեց նաեւ յուրաքանչյուրի պարտականությունը բարելավել, պահպանել շրջակա միջավայրը ներկա եւ ապագա սերունդների համար։ Այնուհետև մենք ունեցանք հաջորդ կարևորագույն իրադարձությունը 1982 թվական։ ՄԱԿ-ի գլխավոր ասամբլեան ընդունվեց բնության համընդհանուր կանոնադրությունը Charte mondiale de la nature ֆրանսերեն դիմակով, եւ այստեղ արդեն գիտակցվում է, որ մարդը ստեղծության ձևափոխում է բնությունը, կարող են սպառվել բնական պատճառներ։ Եվ առաջին անգամ կյանքի ցանկացած տեսակ ճանաչվեց եզակի, արժանի պահպանման եւ ինչն է կարեւորը, որ էկոսիստեմները ունեցան սեփական արժեք, անկախ մարդու հետ փոխհարաբերությունից։ Հիմա սրա մասին մենք ավելի մինչև անցնելը բնապահպանական էթիկայի հասկացությանը, հաջորդ փուլը, որ տեղի ունեցավ այդ զարգացման փուլում, ստեղ են էվոլյուցիա եւ այնուամենայնիվ որ դասավանդում է բնապահպանական իրավունք, եւ այս փուլերի մասին ինքը դասավանդում է, 92 թվականին մենք ունեցանք Ռիոյի հայտնի կոնֆերանս։ Այստեղ հայտնվեց կայուն զարգացման սկզբունքը, իրավաբանորեն, իհարկե զարգացող երկրները պահանջում էին, որպեսզի ամրագրվի իրենց սուվերենությունը, այդ բնական իրենց յուրիսդիկցիայի ներսում բնական ռեսուրսների նկատմամբ որ ամրագրվեց, սակայն նաև սահմանվեց պարտավորություն, որ չպետք է վնասեն այլ երկրներում, ուրեմն այլ երկրների շրջակա միջավայրերին։ Ամրագրվեց զգուշավորության սկզբունքը, principle of precaution, բնապահպանական վնասը, որի մասին մենք անպայման կանդրադառնանք, եւ կենսաբազմազանությունը ճանաչվեց մարդկության, մտահոգության հավատքը։ Եթե մենք այստեղ նայենք միտումը, մենք ազգային պարկերի պահպանումից անցում կատարեցինք կենսաբազմազանություն, կենսաբանական ռեսուրսներից անցում կատարեցինք կայուն զարգացում։ Մինչև խոսել է կայուն զարգացման մասին, կուզենայի հատկապես կարևորել բնապահպանական էթիկայի կարևորությունը, եւ այստեղ նաև ակադեմիական կառույցները եւ բոլոր համատեղ մենք այստեղ մեծ աշխատանք ունենք, դաստիարակության մարդու եւ կենթանի եւ ոչ կենթանական աշխարհի միջեւ այդ հարաբերություններն են հանդիսանում, որտեղ արկա է երկու հիմնական մոտեցում, անթրոպոցենտրիկ եւ բիոցենտրիկ։ Այստեղ ես նշել եմ, որ առաջինի պարագայում ըստ էության ամեն ինչ կապվում է մարդու հետ։ Որ կենսաբազմազանությունը ռեսուրսները դրանք փոխանցում ենք ապագա սերունդներին։
Biodiversity is something that we transfer to the next generations. It is not by chance that when we speak about the natural resources of our environment, we always speak about future generation, local community. It is directly related with human rights. But the biocentric approach has a different approach, that each of these elements have their own value regardless of the relationships they have with human rights. So here, I don't know why this is blank. It says Hans Jonas. I would advise the principle of responsibility, which is based on fear. He says that human beings supervise, oversight the nature through technologies. Nevertheless, it is not supervising the technologies that human beings are using. Therefore, we have a fear of ensuring that we provide supervisory functions over ourselves. So there's the axiometric of the rights that the future generations, we have obligations toward the future generations. However, in time-wise, we will not be able to implement these rights. So especially globalization, technological development, as a result of this, we know that the rights have undergone such great changes. Now everything becomes a rights topic. Memorial laws, when we remember the genocide victims, we take laws for them in the past, we bring the rights for future generations, they come back to our legal sphere. The legal system, if we are we students, we are able to see a pyramid. You cannot do it a pyramid anymore. Next to the positive rights, there are different fragmental sections. It can be a number of US Constitution, anti-corruption constitution, they can have their activism. We have the soft law here. So all of these we should consider from a different perspective. And environmental ethics and seeing rights from a new perspective allows us to speak of, I hope that during the second session, also Shaul will speak about the Latin American countries and their experience, which they have made a transition from natural rights to the rights of nature. Rivers, lakes, they have their rights, they're subjects to have rights. As a very well-known scientist, Manu Busak says, the right of nature is rights without human beings. The rights of nature, of course, a number of issues come forth. Doubt is cast on human rights, the essence of civil agreements, political conflicts. Who is a priority, nature or human beings? Because if we're an academic institution, it's possible that we can come forward with theoretical topics, of course, but I believe it's worth discussing because these would have a very important implications on constitutional rights, as Latin Americans mentioned. Nature can have unique rights as it only has at its self-restoration, but it also, many of the rights that nature has coincide with human being rights that human beings have, that is applying to court, asking for compensation, right to property, right to ownership. But Latin Americans say, like half jokingly, but nature maybe don't yet need political rights. It's not like the tree should come to the parliament, right? Of course, it is, at least at this moment, politicians can rest at ease. Of course, here we have certain approaches, naturalist approaches, convention approaches. As I already mentioned, these are already related with the fact how nature, the right of nature is presented. These are so. Now let's speak about the environmental agenda. First item here is as the first rights. Here again, I will share Sharon. I've heard her presentation. She will present how is this right ratified. So, law, which is we do not declare here values. We name the values. We just say this or that value. And according to that, we define the necessary behavior we expect and the punitive measures and its measures. So in the second chapter of the Constitution, ratified as a right, our new Constitution says the second chapter is directly, it tries to suppress public officials. Let's say if the parliament comes up with certain laws, or let's say the court comes up with certain verdicts, these are indirect results. With the second chapter, kind of suppresses them. So considering this not as a main right as a result of the previous Constitution, we regress. So then the polluter should restore. This is the principle that we have. The obligation of each and every one of us to restore and improve the environment. The Constitution should also set forth how to prevent certain behaviors, how to prevent the damage caused to the environment, or at least limit the effects of these damages caused. These are at least the baseline points that many courts of different countries have developed and further. So this principle of prevention, European countries, many of them, they have decided to ensure the principle of vigilance, obligation of vigilance. I believe one of the most important items I will be speaking about is environmental responsibility. Defining environmental damage as a category. The next is principle of precaution. I have translated this term. I don't know whether this works well, principle of precaution or not. It's my translation. We know that science has something new and new achievements, but we might not know what the consequences could be as a result of this or that activity. But if there is a potential risk of damages, we will see it in the future. Therefore, today, many European countries, this principle is spelled forth, which ensures that countries, nations should ensure that they have the necessary instruments for risk assessment and the necessary processes should be in place that even if such risks do come forth that science now cannot predict or forecast, there is a level of uncertainty to ensure that the effects are mitigated. Here, of course, we have the Orwell's Convention about information accessibility, accessibility of justice. Why is this important? Because from here, many countries are considered anti-constitutional when not the direct participation of citizens are part of it, but it's just the results of the Republic hearings are not taken into consideration. So here, this is spelled out very clearly that the Parliament must ensure that the results of public hearings should be taken into account. So the Deputy Minister today spoke about the environmental agenda. We should ensure that our education should have an environmental direction, but science and innovation, they should promote the preservation and valuing of the environment. So, speaking about environmental responsibilities, so far, initially, there is a very important principle. That is the principle of freedom.
Article 39 that man is free to do whatever does not violate other people's rights and that does not defy the law and the Constitution. So from this perspective, civil responsibility, what does it define? It defines, presumes responsibility before someone. And environmental responsibility is based on a whole different philosophy that is responsibility not before no one really. There's no violation of any specific person to say. If in criminal cases we have charges and we have crime, and if in civic cases we have risks and victims, if in environmental cases we have risks, danger as well. But when you are dealing with environmental risks, we're talking about transpersonal relationships. You are responsible for certain situations, certain consequences. And in this regard, environmental responsibility is a unique type because which defines in a certain way the concepts and freedom. And this should be defined and affirmed by the Constitution, so that there can be charges incurred against such kind of damages as well. Let me go ahead and tell you that environmental damage, as a rule of thumb, there's two different approaches. There's human-centered and non-human-centered approaches. That is the damage incurred towards different elements of the ecosystem, fauna, flora, air, soil, their functional processes, their functionality, and as such, of course, it's mentioned there separately. It is the gain, the collective gain that humans receive. So if a person is swimming in a clean, pristine water, breathing clean air, their rights are kind of violated as well, because there are three main components in multiplicity and environment. So when you study all the proceedings and all the final decisions made in the court, the charge is specific for example, killing this many birds or animals and so on. So ecosystem and its elements have their balance value. They have their own unique single value, regardless of the activities of human. And this is these are the damages incurred against specific elements in the ecosystem. And as damage, it is the whatever we harvest from the nature, what we receive, the collective damage incurred to it is included as well. And an important concept here is the restoration that should be done to the best way possible. If in cases that's not possible, again, the entire damage should be recuperated, to be rolled back to the previous state. So if it's possible to bring restoration to this little pond, or bring back the biodiversity inside that specific habitat, you need to create a new environment. So the restoration should be done to the best and to the maximum possible. As far as the damages to the environment are concerned, the main specificity, as I mentioned, the person is not individualized here. It's not personified. We're not, talking about the different kinds of damages to the possession, to the human being per se. The definition here is a little uncertain, but there's another institution that is included here. That's sanitary responsibility. Gariana sent me a lot of different applications that have not been accepted because they're not included anywhere in the substitution. There's no institution as such. What is sanitary responsibility? It is not predefined by the Constitution, so we do know that in Armenia we have different individual mines. It is presumed that due to their activities, there might be certain damages incurred to human health, and the uncertainty here is not who specifically the damage is incurred to. Sorry, not specifically, taken into account the pathologies and the damage to the health that might be incurred, but it's really who the victim might be. Obviously, it is the community, the residents of a specific area. It could be the person themselves, the community at that given time, but also their future generations. But because there's no sanitary responsibility induced, what do we see here? In countries when it's actually implemented and applied as two different types of responsibilities. From on the one hand, we have what we've done. We've expanded the scope of responsibility. I would venture to say for the first time, when prevention came to the fore, it entered the arena. You need a specific action for to incur charges, but and then we have to deal with the concepts of the multiplicity. Who can really refer to the court with a case? There can be anything, literally local governments, local municipalities, individual citizens. But there's a tendency in many countries now that the individual responsibility is not only the company who has incurred the damage, but also the mother institution, the mother company who has funded and hosted the sister company. So it is the expansion of responsibility and the multiplicity of different subjects, both the subjects that are to be held responsible, but also the ones who will apply. In the case of sanitary damage, we need to understand who can be the applicant, who is going to represent the interests of this group. Was it the civil society institutions, NGOs, or local municipalities? Who are they going to be? Obviously, a lot of funds need to be redirected to research and science so that we can, to the best, mitigate these damages. And as I already mentioned, it's the nature of these subjects that we deal with here. They're transpersonal and they're not personified. If before, as a rule of thumb, was the rule of balance and symmetry, there were two values and the needed to be balanced. It could be in freedom of speech, personal life, freedom and security. There's another important principle that we have to deal with that is not part of our government. It's the principle of precaution. And we really need to just take a moment to try to assess how real, how dangerous this uncertainty is, how dangerous it is, that risk, because if responsibility was all about the risk, it's the danger of the risk we have to deal with. So it's a legal issue. We need to be able to assess how real, how tangible could the danger of the risk be, so that it can be actually measurable. So all specialists, all economists, philosophers need to come to terms and try to research in joint effort to find solutions for these problems. I'll try to limit my presentation. If you have questions, I'd be happy to hear them. Thank you very much for organizing this event. Thank you for your presentation and viewing all these environmental issues from the perspective of USAID. I'm representing USAID here. The management of water resources in Armenia and their improvement. I'm both very excited by what Ms. Gabriela said, and all of these constitutional reforms and the core approaches that have been demonstrated here is that Armenia is either is in need of a code or at least a framework law, or at least for policy on ecology and environmental policy, either one of these three, and taking into account that the law on bylaws, they categorize horizontally. As the do not really see a need here for an environmental law or just a suitable law for it to become a constitutional law to enjoy that status. Policies, principles, relations, human rights, and nature's rights for them to be protected and to be included in such a strong law and be prioritized to this extent. Thank you. Mr. Amirkhanian, I had 25 minutes and I don't think I've overused the time that I was given. Thank you. I'm not. Okay. Yeah, we're on track. Both the ambassador and other participants here mentioned today they had done a project before. Nathaguri Kudan is one of the experts who was involved regarding water resources. I wanted to suggest the commission to about the right of clean drinking water. That's a very unique type of right that unfortunately not everybody can enjoy today. They're villages, rural communities that do not have centralized water supply today. And obviously this stems from the uniqueness and the specificities of the countries, but there's the right for clean drinking water, too important, but also mobility inside Armenia. It is difficult for a lot of people to come to the regional center or to Yerevan. There's no public transportation available for them. These are two important rights that need to be defined. And excuse me. And we do have a hold strongly to the principle of sustainable development in the Constitution. And let me tell you what it presumes. There's the economic, social, and environmental rights and the unity thereof. But economic right is in the prevention of misuse. There's the social right, which is also the humanitarian right, is implemented in two main fields, both intergenerational and transgenerational platforms. When it's the transgenerational, to respect the rights of future generations, intergeneration principle pays due regard to the rights and the responsibilities of your own generation, because there's social rights, and unfortunately they were eliminated from the second chapter of the Constitution. There's the responsibility, the rights to well-being and health. And this is the kind of stuff that does not really necessitate a lot of resources. We just try to prioritize, emphasize the important matters and try to find consensus inside the community. So obviously when we say the life, the right to life or well-being, we do not understand under this providing apartments for each and every single human being, but it's all about the strategy. A person who can enjoy the right to live in an apartment. So it's all about the strategy that we maintain. I believe this stems from the sustainable development principle. We were talking about water supply, and I believe the right inside Armenia is really important. According by the Constitution, people enjoy the rights to leave the country. I mean, want to Kalavan or community in Garatuni. There's literally no public transport, and it does not really presume a lot of financial investments. Every village should be connected to the regional center, to the regional capital. And your suggestion was very important and very plausible to give it the status of a constitutional law. I am going to propose this in the government as well as this becomes very relevant. There's many different codes of laws that we have on election and so on. Why not create a code of law on environment? Let me also tell you that we're going to also study the gaps and going to analyze the policy in the area of water. So I hope there'll be edges for participation. The sooner you do it, the better. For example, Transparency International sent us a very good report on the I always bring this as an example. A lot of laws that are enacted, they're not even included in the e-draft. They're not even discussed publicly in any way. For example, the legal regime of quarantine. I read every little draft that is uploaded on the platform, but I spoke about the socioeconomic rights, and the sooner you do it, the better, because right now we're working at full speed. Thank you very much for presenting this problem in such a comprehensive way. The major setbacks in terms of the protection of environmental rights that we had unveiled on Earth and discussed with you before, and how highly we were emphasizing human and environmental rights as part of human rights and the constitutional guarantees and the concept at large. The biocentric approach was also very interesting here. I think it's part of the discourse now. That's another side of the whole discussion that has been non-existent in Armenia for a long period of time, at least on the legal platforms and the legal discourse at large. I'm convinced that this will be a good opportunity, but also raise the need to firm a lot more guarantees in this regard. Living in a healthy and clean environment and in a country, it is the responsibility of the state, environmental information as part of delimitation of West property, the protection of environmental rights. Beyond that, I want to understand what are the other principles or rights based, of course, on your presentation that are in need of constitutional proclamation. We were talking about the principle of cautiousness and precaution. Is this in progress, or what are the successes that you have accomplished so far? Maybe, will you share this with the Commission? What are the principles, the main principles, the main setbacks that are in your focus at this point? Well, it's not me who will be sort of proposing this principles. Obviously, that's even very well reflected in an EU directive. So we don't really have to invent the wheel from scratch. We need to appropriate and we need to adopt. We're drafting the concept now. I think the drafting is the first. I think in December we'll present the draft of the environmental rights along with socioeconomic rights. the committee was faithful to the approach that you don't really need to touch upon human rights. They're perfect and questionable, and then there's constitutional court and so on and so forth. We were discussing the way of governance and the chapter on basic human rights. I do not think it was really prioritized at that point. So in those directions, we have included this, and I want to emphasize that if you look at the recent years, the constitutional reforms that have taken place, a large part of it do follow an environmental agenda. So when we're in Hague, the participating expert will be next to speak. You'll hear her soon. I think it was in Chile. I think Latin America is very straightforward in this regard. There was a special committee put together for the development of an environmental agenda. We're talking about the agenda in Italy. So they have put together different committees, specific committees for this matter, this is the reason why such events are so important, so significant. One event like this would not be enough. Without affirming constitutionally, no event could really accomplish this. And I think this chapter can only be changed and amended through I believe that the human rights it necessitates a full call. Once the first phase is over, we'll be moved on to drafting it. We will suggest to bring from the third chapter, the environmental chapter from third to the second, and it will be passed on to the committee. And as I already mentioned, stemming from the specificity of Armenia, I'm going to be proposing the rights for clean drinking water and transportation. For many years, not a single village has received irrigation water. So you need to develop, there's a lot of cost that it can incur, but it could be done, several villages at a time. And when the research was conducted with the help of the Swedish government, like Arthur said, in many villages, the quality of drinking water was exceptionally low. You always give me the topics for discussion. We can always converse over these topics or not. I'd be only happy to be involved. There's an organization in Hague called AUA that supports different states in the country to implement these constitutional reforms. It's an international organization, and we are cooperating. They're cooperating with our committee as well. We were invited to Hague in June, and we held the discussion together. The main issue discussed was parliamentary minorities, and there I met Shannon, who works there as projects manager, and you can see what she's involved with in the agenda. And I think she will present the best practice in the arena of environmental protection, and she'll speak about the Latin American practice as well, and more specific issues in this agenda.
Hello, everyone. Can you hear me and see me? Excuse me, I'm just hearing the interpretation over myself. 1 second.
We can hear you well, sure.
Thank you. Perfect. Then you can see my screen?
Yes.
Thank you so much for confirming. Minister, Excellencies, colleagues, and organizers, many thanks for the opportunity to join you today for this most important and timely conference. Even though I'm not with you in person, I am very honored to be part of these discussions. So as I was introduced, my name is Sharon Piehiki, and I am a member of the Constitution Building Team of the International Institute for Democracy and Electoral Assistance. Along with my colleagues, I support constitutional reform processes by producing comparative research on constitutional process and design. Considering today's topic, I will be presenting some overarching issues related to constitutionalizing rights and protections for the environment. Then I will provide examples of substantive and procedural environmental rights in constitutions, state duties, and provisions related to natural resource management. Finally, I will cover an important and overlooked topic in these discussions, and that is constitutionalized institutions that can monitor, adjudicate, and enforce protections for the environment. When we look at the overarching issues and trends related to constitutionalizing environmental rights and protections, our first roadblock tends to be what we call the democracy problem. And that is, responding to environmental degradation and climate change necessitates long-term planning and decision-making, along with potentially unpopular policy-making. Short-term election cycles do not favor either of these things. A related issue is that constitutions represent the constituent power, the people, but combating climate change necessitates thinking of future generations rather than just the shorter-term priorities of the current living generations. So how can this be addressed? Well, we can theorize the role of constitutions in many ways, but a strikingly important theoretical framework in relation to the climate crisis is to understand constitutions as risk management tools, and to understand climate change as an example of an irreversible harm. This irreversible harm threatens life and health, which creates a morally unacceptable and inequitable situation for future generations. We're at the point in our collective knowledge where we see the impacts of climate change already, and we know that worse can still come. We have therefore arrived at what is called a window of opportunity, where issues related to climate change are reaching policy agendas throughout the world, as illustrated by state commitments to reduce carbon, increasing public interest in state commitments at COP, the UN's progressively strong statements on human rights and climate change, and the proliferation of citizens' assemblies on climate change. What we do now with this window of opportunity is crucial. Constitutions may play a key role in this, providing a stable basis for environmental democracy. They can inculcate protection of the environment and build more robust and institutionalized responses to climate change. Perhaps the most salient reason is that environmental provisions and safeguards contained within constitutions have the potential to bypass short-term political considerations, which are tied to election cycles, and instead favor longer-term protection of the environment. For my talk today, I will provide a broad overview of the types of provisions currently included in constitutions that can help us understand the spectrum of options currently available to us. But we also must bear in mind that innovative responses to climate change are still needed, and we will not address this challenge using the same outmoded ways of thinking. Starting with rights relating to the environment, which David covered also earlier. Broadly speaking, constitutionalized environmental rights fall into two categories, and these are substantive rights and procedural rights. More than 3/4 of the world's constitution include explicit reference to environmental rights or responsibilities. Within substantive rights, the most common approach is a human rights-based or anthropocentric approach, with constitutions most frequently safeguarding the right to a healthy environment for people. At last count, 96 national constitutions recognize the substantive right to live in a healthy environment, and this is with varying formulations. The right is generally understood to encompass the right to work and live in a safe environment, clean air, clean water, and protection of biodiversity, among other things. In some countries, without the constitutionalized right to a healthy environment, courts have judicially interpreted environmental rights through other human rights, for example, the right to dignity or the right to life. Within substantive environmental rights, other rights are also implicated. For example, security of the person, food, sanitation, property, and health. Last year, as already mentioned, the right to a healthy environment was recognized by the United Nations as an international human right, important and actually crucial for the enjoyment of all other rights. Excuse me. Okay. I will now turn to the right of nature itself, as opposed to nature as a collection for resources of human use, which has already come up in our discussions today. As mentioned, it's an emerging issue in environmental constitutionalism. This approach, which, as David mentioned, is still quite rare outside Latin America, advocates for ecosystems such as rivers, lakes, and mountains to bear legal personhood, and is often rooted in indigenous worldviews. However, my prediction is that this right, the right to nature, is going to be increasingly included in constitutional reform processes around the world, including in Europe. And I say this because just last week, Ireland's Climate Assembly on Biodiversity, Ireland's Climate Assembly on Biodiversity Loss recommended to constitutionalize the rights of nature. And they based this in ancient Irish laws that protect forests. So I do think that countries will start reclaiming this right of nature through their own historical, cultural, spiritual contexts. In 2008, Ecuador became the first country in the world to recognize and implement the rights of nature in a constitution. So this right within Ecuador's constitution recognizes the rights of nature to exist, to persist, to evolve, and to regenerate. It includes nature's right to be restored and a corresponding state obligation to restrict and prevent destruction of ecosystems. As with the human rights-based approach, the right of nature's location within a constitution, its transformation into legislation, and its enforceability are crucial to its efficacy. Complementary procedural rights are also vital to enforce substantive constitutionalized environmental rights. These procedural rights, as also mentioned earlier, are the three pillars of the Aarhus Convention, and they're generally formulated as the rights to information, participation, and access to justice. And they also have a corresponding state obligation to ensure these rights. So approximately 36 countries have constitutionalized procedural rights specifically for environmental matters, but others yet enshrine generic procedural rights that can also be used for environmental matters. To briefly touch upon the main aspects of these rights. Firstly, the right to information in environmental matters includes two parts. The first part concerns the right of the public to seek information from public authorities and the obligation of those authorities to provide that information. The second part concerns the right of the public to receive information and the obligation of authorities to collect and disseminate this information of public interest without the need for a specific request. The right to take part in decision-making processes, including in relation to environmental issues, can be divided into three parts. The first concerns participation of the public who may be affected by or otherwise interested in a certain process, decision-making activity. The second part concerns the participation of public in the development of plans, programs, and policies related to the environment. And the third part is the participation of the public in the preparation of laws and policies relating to the environment. This right also includes the right to be consulted, which is particularly important in terms of the extraction of natural resources and mining. We see this right in the Bolivian constitution, where nations and indigenous peoples have the right to be consulted each time legislative or administrative measures may be foreseen to affect them. The right to prior obligatory consultation by the state on exploitation of non-renewable natural resources in their territory. It shall be respected and guaranteed in good faith and upon agreement. The third pillar of the Aarhus Convention, also reflected in constitutions around the world, is the right to access justice to vindicate violations of environmental rights. There are three components of constitutionalized avenues for access to justice in environmental matters. These are 1, broad standing rules, 2, the rights of individuals and groups to seek redress for environmental harms, and 3, adequate and effective remedies, including injunctive relief as appropriate. These must be bolstered by fair, equitable, timely, and not prohibitively expensive procedures, and a dissemination of information about such mechanisms. A supplementary right to just administrative action offers an additional layer of oversight and an avenue for citizens to challenge state decisions regarding the environment on the grounds that they were unlawfully or procedurally unfair, alleging, for example, that an environmental impact assessment was insufficient. Moving on to other types of constitutional provisions related to environmental protection. We have identified approximately 144 constitutional state environmental duties, which imposes upon the state an obligation to conserve or protect the environment. There are various formulations, but these provisions might include, for example, controlling pollution, prohibiting the importation of toxic waste, creating natural reserves and parks, promoting environmental quality of rural areas, and ensuring that tax policy renders development compatible with the protection of the environment. Some constitutions oblige the state to pursue a policy of developing and producing renewable energy to ensure cheap and dependable supply of energy to citizens. Some constitutions link the duty of the state to protect the environment with protecting future generations, and others connect the state's duties with principles of sustainable development, like in the case of Armenia. Given the centrality of natural resources to a state's economic development, it's not surprising that most, if not all, constitutions contain provisions on natural resources such as water, land, forests, wildlife and mining, soil, subsoil, and air. Like the environmental protection provisions, these generally fall into rights and responsibilities. So these constitutional clauses often are pertaining to ownership of natural resources. So the state's rights, for example, to exploit, grant concessions, restrict use, and the state's obligations to manage, conserve, and rehabilitate those resources. A rare but increasingly used type of provision is that of fixed commitments relating to environmental protection. We have an example in the Kenyan Constitution, which obliges the state to achieve and maintain tree cover of at least 10% of the land area in Kenya. Fixed commitments, I think, may become more popular. They are generally more precise than other constitutional provisions, giving a precise quantum to limit contestation on the requirements of fulfilling this constitutional provision. So they control the magnitude of activity that is to be permitted or required of governments or other actors, and may assist a state in successfully reaching its international commitments. While there's general overlap with natural resources provisions, for Armenia, I thought it's worth noting that around 60 constitutions explicitly mention mining, with Bolivia's constitution dedicating an entire chapter to regulating the various aspects of mining in detail. Several constitutions also expressly entrench what's called the polluter pays principle, meaning that liability for environmental harm lies with those exploiting the resources and producing pollution. This principle also extends to managing the costs of pollution and compensating victims of pollution. For example, Vietnam's constitution states that organizations and individuals who cause environmental pollution, debilitate natural resources, and weaken biodiversity shall be strictly dealt with and must be responsible for remedy and compensation for damage. Very few constitutions, approximately 11, reference climate change in relation to state environmental duties, but it is likely that future reform processes may incorporate such provisions. I include the example of Ecuador's constitution, which is perhaps the gold standard because it is most concrete in its formulation. It says, the state shall adopt adequate and cross-cutting measures for the mitigation of climate change by limiting greenhouse gas emissions, deforestation, and air pollution. It shall take measures for the conservation of the forest and vegetation, and it shall protect the population at risk. So as you can see, that's an incredibly comprehensive provision that links all of the state duties to combat climate change. Chile's constitution was also mentioned earlier, so I briefly wanted to note that indeed there was a committee that was set up to look at the environmental issues in Chile and present them for the plenary to vote upon. This commission was also charged with looking at the economic model of the country, which is essential when we are having these discussions. So this commission suggested over 100 provisions related to the constitution, and had the referendum passed, Chile's really would have been an ecological constitution, as we say. And we can talk more about that later if you like, but there are many innovative provisions that also came from the Chile process. I now turn to a crucial part of the discussion, and that is an exploration of the unique potential of constitutionalized institutions to promote compliance of environmental law and enforcement of environmental rights, to address climate change, combat environmental degradation, and promote a just transition under the umbrella of sustainable development. Firstly, I will touch upon environmental courts and tribunals. In 2016, it was estimated that there were over 1,200 environmental courts and tribunals at the national and provincial level in 44 countries. Few of these courts and tribunals are constitutionalized, with the very notable exception of Kenya and Bolivia. But all of these courts and tribunals, whether constitutionalized or by statute, have proven themselves crucial in advancing environmental rights and enforcing environmental protections. Specialized courts are important because they can generally respond more quickly to environmental concerns, and this can counteract the usually very slow process of courts. But relevant environmental laws and constitutional provisions must exist for them to be successful in carrying out their mandates. Further, these types of bodies face particular challenges in environmental matters as they deal with issues of definition, for example, environment. What does healthy mean? What does quality mean? And boundaries of those definitions. They also have to deal with appropriate remedies, compensation, injunctions, alternative measures. They face issues with funding and staff, of technical knowledge, and of course, potential political fallout for potentially unpopular decisions that they might make. Of course, in the absence of, or in addition to environmental courts and tribunals, constitutional and Supreme Courts also have a role to play in the enforcement of environmental rights. In addition to courts and tribunals, some states have specialized environmental prosecutors at the national and sometimes the sub-state level. These specialized environmental prosecutors are generally mandated to prosecute violations of environmental law by public and private entities. This is often related to water or air pollution, hazardous waste, dangerous substances, or protected lands. I'll give you the example of Brazil. Brazil's wide-ranging environmental laws are enforced by the Ministério Público, which is empowered by the 1988 Constitution to monitor and enforce violations of constitutional rights. And this in Brazil includes the right to an ecologically balanced environment. The Brazilian Constitution mandates the public prosecutor to instigate investigations and litigation to protect public and social property, the environment, and other diffuse and collective interests. It also is empowered to defend judicially the rights of indigenous populations. So the Ministério Público enjoys constitutionally protected functional independence, and it has been very active in environmental cases in Brazil. For example, in June 2020, a group of 12 federal prosecutors filed a suit against the federal environment minister, and they accused him of trying to dismantle Brazil's environmental policy. That minister has since resigned. Turning to independent regulatory and oversight institutions. There are many types of these independent regulatory and oversight bodies that may be established by statute or in a constitution. National human rights institutions can play a crucial role in promoting and protecting human rights, including those constitutionalized environmental rights we discussed earlier. Some national human rights institutions have developed innovative policies on monitoring and evaluating government environmental protection efforts to bridge the gap between stakeholders in extractive industries and to protect human rights. For example, Argentina's National Human Rights Institute has developed a monitoring and evaluation program to identify gaps and challenges in the state's implementation of the Sustainable Development Goals, and it does this with input of civil society. Another example is Mexico's National Human Rights Institution, which can accept and act on environmental complaints, and this was after the 2012 constitutional edition of the Right to a Healthy Environment. Some constitutions establish the office of a general human rights ombudsman, which can also be responsible for issues related to the environment. However, there are also states that constitutionalize more specialized environmental ombudsmen, so-called defenders of nature, or an ombudsman for future generations. These can actively monitor executive decision-making related to the environment and pursue vindication of individual or community rights to a healthy environment. I must give the very famous example of the Hungarian Ombudsman for Future Generations, which, through the Hungarian Commissioner for Fundamental Rights, can approach the Constitutional Court to seek annulment of legislation that will endanger future generations. This recently resulted in the invalidation of key aspects of Hungary's forest management legislation, which was not adequately taking into account the transgenerational burdens of the policy. So in conclusion, by surveying constitutional text, we see a wide variety of provisions relating to environmental rights and natural resource management, but their implementation depends on a robust institutional framework. A core benefit of constitutionalization is that it can embed long-term environmental planning and commitments as part of a country's vision, inoculating policies against shorter-term political considerations. Constitutionalizing institutions ideally strengthens their authority, independence, and longevity, but there are also risks. These institutions' effectiveness in carrying out their respective mandates must be considered within the overall political framework of a state, including the availability of political will to abide by and to implement their contributions. As mentioned earlier, discussions on the environment and natural resources cannot be divorced from conversations about the economic model of the state and long-term management of depletable resources, including the extent of the state's reliance on extractive industries and its capacity for and commitment to a just transition. To prevent the worst impacts of climate change, the world has a brief window of opportunity, and it really is up to us how we use it. I thank you very much for your attention. I welcome questions, and also a big thanks to the interpreters for sticking with me.
Thank you very much, Sharon. I learned something. This was a very, comprehensive and at the same time, very succinct presentation. So you can see your screen also, by the way, or is that our screen? Oh, sorry, that's, yeah. Okay, any questions? Harserkan? Okay. All right. So Sharon, let's listen to the next speaker, and maybe all these will come together, and we'll have because in some ways they're interlinked. What Jane is going to talk about, Jane Suter from Dublin is going to talk about is not specifically about environmental rights, though she may have examples of environmental rights, we'll see, but generally engaging citizens in constitutional reforms. And as as Sharon mentioned in her talk, there is kind of a tension between public participation, citizen participation, short-term needs of the country and long-term vision of the Constitution. So with that, we're very happy that Jane had time to join us. She has, she's one of the key people in Ireland on citizen assemblies and constitutional reform. And so, and so we're looking forward to learning more about their experience. Are you trying to share, Jane? Yes. Can you hear us? And you're on mute.
Apologies, I'm trying to, something has gone wrong with my Zoom. It's not allowing me to share. So I'm attempting to email it to you. So perhaps you can share it from there. Would that work?
You can email it. Yeah. You've emailed it already?
It's just sending as I speak. I'm just watching the blue arrow go across. So apologies for that. I don't know. I've sent it to Alan and to Rosanna. If it takes a minute, I can just talk anyway without a PowerPoint, but whatever you like. I don't know what's happened to my Zoom that it's not recognizing PowerPoint. We had an update in my university, so maybe there's some setting has changed somewhere.
Hey. Okay, Jane, you can talk and I'll can she control or?
Okay, and then I can let you know when to move on. So hello everybody, and apologies for this little hiccup at the beginning. I'll have to work out what's going wrong with my PowerPoint. But just as you just heard there, I was going to talk to you more generally about involving citizens in constitutional reform, and I'll try to focus a bit on climate and biodiversity loss and so on, which are some of the issues that we've been looking at in Ireland. But I suppose before I come to that, what I wanted to talk about was the sort of the principles of citizen deliberation and involving, we call them citizens, but of course it's not always citizens. You know, in Ireland, many of the people involved are people who weren't born on the island, who don't necessarily have constitutional voting rights as citizens and so on, but it's just the established shorthand for it. So what I thought might be useful for you all on the next slide is to talk a bit about the deliberative experience. So I'll talk a little bit about why citizens' assemblies, what they're useful for, where they come from. I'll talk a little bit about what kind of topics are suitable, and then the connections with policymakers. So how you build that, I think that's absolutely crucial. And then connections with the mass public and the mass media. So if we go on just one slide to why citizens' assemblies. The idea is that the governments and policymakers are largely used to listening to civil society, to vested interests, to lobbyists and so on. But they don't generally listen to citizens. So often they actually have a not very clear view of where it is that citizens are on an issue. So I'll describe to you later, but for example, for 30 years in Ireland, there was a big discussion about abortion rights, abortion had been completely outlawed in the Irish Constitution in the early 1980s. And politicians had assumed that this was going to be very difficult for citizens to bring it back in, because they had only heard from, very committed lobbyists on both sides, some of them well-funded by American groups and so on. But once they actually brought the citizens in and the type of people who don't normally participate, then they began to get a different picture, and it also builds trust among citizens. A lot of the research shows that particularly citizens, younger men and others who are more distrustful of politics and of politicians and of civil society and so on, tend to trust citizens' assemblies more. They see them as people like them, people who've been able to subject scientific expertise to questioning, which is quite an important part of it. So if we go on to the next slide, I just wanted to talk to you a bit about Ireland's first experience with deliberation and where we came from. So at that time it was 2008 and the main to 2010, and the main crisis, the main issue facing Ireland and obviously a lot of European countries and so on was the recession. In Ireland we were particularly badly hit, and the IMF and the World Bank and so on were in, so people were on the streets about this. And I suppose now we're while the climate crisis was definitely in view there, it wasn't so much on the landscape of the average citizen, but it's this type of crisis situation that often allows a government to think a bit differently and to think about other ways of involving their citizens, of trying to build trust and build legitimacy and so on. So I just talked to you a little bit in the next slide about Ireland's first deliberative experiment, which was called We the Citizens. I think it's one slide back from the one that you're showing now. And this was an academic experiment that we conducted in order to demonstrate to politicians and policymakers and civil society, senior civil servants, and so on, that in fact you could trust the people, you could listen to them. There had been citizens' assemblies beforehand in British Columbia and Ontario in Canada and in the Netherlands. But a lot of people had said, well, you could trust Canadians or Dutch people, they're very sensible. You couldn't necessarily trust Irish people. So that's why we, with the help of philanthropy, engaged with this first academic experiment. And the really important thing about this is that the people who are invited, who are part of it, you see a photo of them there, must be randomly selected. So in Ireland now, what happens is the Prime Minister, our Taoiseach, sends a letter to maybe 50,000 different households in different parts of the country, in rural areas, in urban areas, in small towns, in large towns, in areas that are doing well economically and areas that are doing less well, and so on. and says, you know, if somebody in this household would like to volunteer for the next citizen assembly, please fill in your details. So people then fill in the details and then are randomly assigned. There's 100 people there. So we have 50 women, 49 men, because there's slightly more women than men in the Irish population. They come from advantaged, disadvantaged areas. There's unemployed people, professionals, working people, retired people, students. In the most recent one on biodiversity, we had somebody who had turned 18 just a few weeks before and was doing their final school exams, and we had somebody of the age of 75, people who were born on the island, people who were born elsewhere, and so on. So it's really just to demonstrate that if you bring these people together, and then really importantly, what you do is you give them good information. So we can go on to the next slide. And the information is balanced from experts. So you have people who give, that's okay, it's the one with the Irish print, yes. You give them balanced information about the pros and cons. If somebody has a very definite point to make, you try to balance it with somebody who says something else. So you'll see that, you know, the first one was on marriage equality, which really got this idea of deliberation in Europe underway, because the Citizen Assembly called for a referendum on marriage equality, and that referendum passed. Ireland became the first country in the world to actually opt for marriage equality by popular vote. And then we moved on to the second one, where we were looking at abortion rights, which I mentioned earlier, and at climate change. So the important thing, as I was saying, was this balanced information. So for example, on abortion rights, there would have been people who, ethicists who would have argued both ways, constitutional lawyers who would have talked about the pros and cons of this sort of thing being in the constitution, gynecologists, and who would have talked about the issues that people can have with different types of pregnancy and so on. But it was all balanced scientific information. So when we looked at climate change, the balance, of course, wasn't having climate change deniers. The question was, how do we make Ireland a leader in tackling climate change? So it became about, well, do we want to focus on agriculture or on transport or on housing and so on. So we, you know, there was a lot of presentations from different people about the extent of the challenge on climate change, but also about the different kind of mitigation and adaptation solutions that Ireland could engage in. And then more recently, we've had one on gender equality, and one that is just almost finished now on biodiversity loss. And I think that one was important, that it was actually framed as biodiversity loss. So it was how to try to stem biodiversity loss. And one of the things, the first round of voting was just a few days ago, last weekend, and the citizens voted for us to put a clause into the Constitution about the right of citizens to an environment where biodiversity is protected. Because one of the ideas is that in Ireland and elsewhere in Europe, there's actually already quite a lot of legislation that, if really properly implemented, could protect against biodiversity. Of course, more is needed, but even implementing strongly what is there would do a lot to protect biodiversity and try to slow down the rate of loss at the very least. So that's why there was a constitutional proposal put into that. So this brings me on to the next topic, which is about which topics are suited. And you can see on the slide that we'll come on to now that, you know, where I first, the next one, about electoral reform. So that's where these started, which were very kind of technical subjects. You know, in British Columbia, they actually spent 9 months thinking about the different types of voting system that they could use before they opted for a proportional one. Those citizens became, you know, real experts in electoral law. So that demonstrated that, you know, things don't need to be kept to top line. You can actually go into quite a lot of detail with citizens, but obviously they need support, they need to learn in different ways, and I'll come to that in a minute. And then we have the moral and social issues, which was the marriage equality and the abortion and blasphemy and so on that you've seen in Ireland. But really the area where citizens' assemblies have taken off the most is climate related ones, biodiversity loss. So Ireland had the first climate citizen assembly in 2016, but since then they've been held in the UK. The House of Westminster in London commissioned one. There's been a climate citizen assembly in Scotland, in Germany run by Bergerat, in France, Emmanuel Macron had the Citoyen de Climate, which was a follow-up to the Grand Débat in France, which was a really detailed look at what French society could do to tackle climate change. Unfortunately, with that, Macron himself had promised to implement some of the proposals, and then he did less. The Parliament with the system there wasn't as involved. So that kind of talks about the importance of the connections with policymakers, which I'll come to in a few minutes. But Denmark has done climate citizen assemblies. They have one at the moment about building a new island in the middle of Copenhagen, where there's going to be significant climate impacts. Estonia has been running, has run a couple of local climate citizens assemblies. So a lot of smaller cities and towns and regions have run climate assemblies and so on. So they're probably the most popular type of assembly at the moment. If we go on to the next slide. One of the things is, if you're going to involve citizens in deliberation, is to think about how you're going to frame it. So values-based framing is by far the easiest. So, you know, if your values are about looking after your community, looking after your family, looking after your children's future and so on, those are the kind of values which people have found most helpful in framing citizens' assemblies around climate or around biodiversity loss and so on. And the other thing is this, as I was saying, you know, you have so many experts coming in to educate the citizens, but it's really important that those experts deliver their expertise in a way that you would for kind of mid-cycle teenagers in secondary school rather than undergraduates. So you have a lot of time for evidence, you have a lot of time for different experts to come in, but it's also important that people hear from other people who are maybe experiencing the consequences of climate change, or people who are concerned about their children, or farmers who are living with something, or so on. And with biodiversity, we've started really trying to expand the way that our participants learn. So they did field trips to areas where there've been really good measures taken to protect biodiversity, and to areas where the things had worked less well, and there was real problems with the absence of biodiversity, so they could really see it in real life, because obviously different people have different learning styles. So it's trying to get that balance right between kind of clear choices between values, between video, audio, text, experiential learning, and so on. So there's a lot that goes in to the actual framing of the argument and so on. If we move to the next slide, you really need to think about this type of evidence and make sure that people feel that they really are being presented with some choices, that they really are able to engage with different people and really think about, you know, what their preferences are for themselves and for their communities. One of the big questions is often what to do about vested interest, because of course, like in some ways, like Greenpeace could be a vested interest, but so is the Farmers Association or the oil extraction industry. So in Ireland, we've come up with a clear kind of way that we treat what we call all vested interests, which is that we have experts who are meant to be either neutral or as balanced one against another. And then vested interests, it's very clearly marked out to the participating citizens that these people are have skin in the game, if you like, and so to treat their evidence different. If we move on now to the connections with policymakers and on to the next slide, I think this is probably the crucial thing, and I think there's, you know, probably a good range of people in the room who can really think about this in terms of Armenia. But on the first slide, on the slide there on the left, you'll see a picture of myself and my co-investigator David Farrell in our very first one 10 years ago, the experiment on We the Citizens that I talked to you about earlier. And we really use that for persuasion for politicians and for policymakers. The woman you see in the middle there in the pinky purple jacket is a former political correspondent for the national broadcaster. So she knew the journalists, she knew the politicians very well, and she was able to go in and discuss with them the benefits of this. So I think that's really important, is kind of building the connections with policymakers. The picture on the right, our very first citizen assembly actually had 1/3 politicians in the room, and we use that to build those connections. Indeed, you'll see that in the next slide. We changed it over then, where we had the politicians, rather than being in the room, brought it to a parliamentary committee. So, for example, when they took the output of the Citizen Assembly on climate change, they then had an all-party committee in Parliament to discuss it, but they were just discussing that committee, and that led to Ireland declaring a climate emergency in the Parliament, and also allowed them to put the bones on the very first Climate Act that they were going to pass. But it is a delicate balancing act. In a very recent one on Dublin and the changing the electoral system, with politicians back in the room again, and of course they acted like politicians and did a lot of lobbying. So I think it's better to try to develop the connections with politicians into the Parliament and so on, into the ministries, rather than necessarily having them in the room. The next slide is just some detail about that, but I see time is moving on, so we'll run past that. And I just wanted to show you here, if you just press forward, we'll see that where we have with the is this kind of tight coupling, as we call it. So we have these pressures for change. So, for example, trying to meet 1.5 degrees of commitment and so on. And before, this would have just gone into legislation or constitutional change. But now, if you press forward, you'll see in the red box that we put this Citizen Assembly in to the middle between that pressure for change, and then it goes back into the traditional system. So this kind of connection, this kind of coupling really builds the presence of citizens in, but that also empowers the policymakers and the government to be able to move forward with changes that in some ways might be too radical for them without the insertion of that citizen voice. So it allows them to move forward with policies that might otherwise challenge them, it might challenge kind of inter and intra-party differences. So it provides that level of connection. But it also provides for the insertion of citizens' voices into the policymaking process, which builds legitimacy for the process and trust and so on. So the very last point I'll make is, if you're trying to do this, it's been done, you'll see a slide 2 ones on called media relations, but there's been a lot of these assemblies in all sorts of countries around Europe and in the US and in Canada and so on. And I think one of the differences in Ireland is that we've really thought about media relations. There's journalists in the room when people are deliberating and listening, so there's full transparency. Everything is live streamed. All the submissions are available for everybody to see, and there's a real focus put on the professional media campaign and the social media presence. And so I think this, leads in some ways to some of the successful referendums we've had, the declaration of the climate emergency, and so on. And we have high levels of awareness of citizens' assemblies in Ireland, and a lot of media coverage. So maybe if you just move forward, we went through a few slides there to the second last one, you'll see some of the pictures of media coverage. So I think about 3 more on from where you are there. Yeah, so we're just moving forward, but if you just go to where next, maybe is going to be easiest. Apologies for this, everybody, for my slide not working. But in Ireland, with as I said, biodiversity is just finishing up now, and we're really hopeful that that will lead to both the enforcement of existing legislation to a much greater extent. It will allow politicians to stand up to some vested interests who talk about kind of traditional farming or turf cutting rights that they have, to be able to say, well, we put it to a citizen assembly and the citizens have recommended this. So we're now talking about using it in areas like neutrality or a border poll, which would be very politically contentious in Ireland. So I think I'll probably finish up there now, and then there's plenty of time for questions, or so I can understand where it is that all of you are on this, because I know it's a little bit different to the kind of more focused talk on environmental policy, which you've been listening to and having and participating in for the rest of the day today.
Thank you very much, Jane. This is, I always get excited about listening to the stories coming out of Ireland, because obviously there's some parallels in Ireland. What of course was in some ways shocking, you expect that, a conservative Catholic country being the first to do marriage equality, have, abortion, which is even unimaginable that Ireland would go for it. And the power of citizen engagement and citizen deliberation is as an untapped resource in many countries. Informed engagement into dialogue, I think, is an untapped resource in many countries. And I think with the Armenian Constitutional Reform Commission, they will be, I think they would get a lot of valuable feedback from citizens if certain elements are put up for discussion. I don't think the entire set can be up for discussion, but certain elements that are critical and it's not politically clear which way people would be happy with, and not rely on the sense of politicians that this is good policy for Armenia, because often they may be wrong. They're wrong, actually. And so I think, on the other hand, the challenge of, the case of Ireland is that, of course, I'm revealing my political biases here. The conclusions the citizens came up with seems to be progressive, moving society forward. But you could also expect that the Citizen Assembly actually pulls back right? And it doesn't let you go as far as you would want it to go as a visionary constitutional reform. But that actually gives politicians some kind of a barometer of where people are.
Mm.
Many different values, type of engagement. Thank you very much.
Yeah, I think so. And but I think there's a difference. Like, it's actually quite interesting to look at the difference between the Irish experience, where we had randomly selected citizens. I think that's the really crucial thing, because if you look at Iceland or Chile, they both had elections for citizens in their constitutional review processes. And in both of those, the process didn't actually proceed. It became more politicized, and the citizens who were involved were perceived as more like mini politicians, if you like, because they'd gone through this electoral situation rather than being randomly selected as in a jury. So I think there's important lessons there in the comparison between elected citizens' assemblies, such as in Chile, and then the randomly selected ones in Ireland and elsewhere.
I was a little bit surprised to hear that there were politicians actually present in some citizen assemblies, as long as they keep point, yes. So, any questions? Yeah, David. Yeah.
Sharon? Okay. I have a question. I wanted to know, can you update us, please, about the ongoing constitutional environmental reforms that the idea is involved in? Just the scope of those reforms, the main tendencies.
Sure, I'd be happy to do so. So I should explain that, International IDEA, as David says, intergovernmental organization, and we provide assistance for in-country reform processes. When we work with in-country reform processes, we never are prescriptive. We only provide a spectrum of options. So that's why I gave some of the options today. But in terms of reform processes, I mean, we're involved in nearly every process that there is ongoing at the moment in some form or another. Many in Chad and South Sudan, the Chile process we continue being involved with. As David said, we're pleased to assist the Armenia process as we're needed. And when we bring to these reform processes discussions about the environment, we really want to think and talk about the context in which the country is operating, the extent of the reliance on natural resources, what types of issues are under review, for example, water issues or mining, etc. And for that, then we will provide what's out there in constitutions already. And I think what is key, what Jane has brought into the discussion as well, and something that we are really interested in, is seeing the extent to which these citizens' assemblies, which are unencumbered by some of the political considerations that have been brought up, may actually provide some innovative recommendations that could in fact be constitutionalized. And so I briefly mentioned earlier, as Jane did, the Citizens' Assembly on biodiversity loss, and the fact that the Assembly recommended constitutionalizing the right to a healthy environment, the rights of nature, among others. And if I may take the prerogative of having the floor, I hope I've answered your question, but I'd also like to ask Jane whether indeed you see any of these climate assemblies coming out with innovative recommendations. And as a second part, do you think that we should be looking towards constitutionalizing citizens' assemblies as institutions of citizen input, as kind of citizens' panels? Or do you think their benefit and their success lies in the fact that they're ad hoc and usually narrow focus or single issue? So thank you for taking that on.
Yeah, sure. So in terms of innovative, yeah, a lot of them go a lot further than policymakers thought. You know, in Ireland, people didn't actually expect the proposals for referendums to actually put the rights of nature and the rights of animals and so on into the constitution. So that wasn't expected. But the citizens, when they heard about kind of the legislation that we had, but the lack of enforcement, really thought that you know, constitutionalizing it would then give citizens extra powers, if you like, to try to ensure that policymakers would enforce things. And some of the really innovative things, actually, in Scotland and in Ireland, we've had children's and teenagers citizens' assemblies running alongside the adult ones. And I think having the children there in Ireland, it was from 6 to 16-year-olds, really provided kind of different ways of thinking about things and different kinds of imagination that, you know, really caught, I think, some of the adults, you know, especially the older ones who were more used to thinking traditionally, but they liked the idea of the more innovative ideas coming from the children. So I thought that was an interesting thing to do. And especially around issues around climate and biodiversity, where of course we're, you know, talking about future generations and unborn generations and so on. So being able to include the children's voices, I think, is really important. In terms of constitutionalizing it, yeah, like in Ostbelgien, so in the German-speaking part of Belgium, they've done this. And there's a sitting citizen assembly that sits as part of Parliament, which is actually quite, and they choose then the topics which are going to be to be debated. Whereas in Ireland, the choosing of the topics is quite top down. The political parties put them into their manifestos, and then they go into the programme for government, and then they're done on this kind of ad hoc basis. But it's interesting that at the moment there's a process, the Biden Summit for Democracy, that the US State Department is running. And Ireland and the European Commission have co-sponsored a cohort on deliberation within that summit. And there's a proposal there asking different countries to sign up for it. And one of those is actually to think about implementing citizen assemblies at different levels and institutionalizing them. So that's something that it'll be really exciting to see which countries choose to do it, because it's most of the OECD, I think, that are in there. So it'll be exciting to see who signs up for deliberation on from that platform.
Assuming it's open to Armenia as well, too. Jane, can you hear me? You're on mute. I'm assuming that international fund that's set up is available for countries like Armenia. Jane, you're on mute. You're on mute, Jane.
Oh, apologies. Yeah, I can actually send the text and the email and the link to anybody who might be interested in it. But yeah, absolutely, Armenia would be it would be fantastic to have Armenia involved.
Excellent. Citizen assemblies is a completely new idea in Armenia. So yeah, turn it on and you tweet 7 seconds.
I think it's on. No?
Can you hear her?
Yeah. Sharon, Jane, thank you so much, both very valuable presentations. I have one question to Jane, and it relates to potential political influences on citizens' assemblies, especially with rather small societies where sometimes intense political processes are being brought forward. I would see this as one of the very important factors that need to be taken into account. So whether you had such an instance where you could observe that political parties, not directly obviously, but are having an influence on the participants of the assembly or on their discussion and decision-making process, and how you handle that, do you have any roadmap for that dimension of potential developments?
Yeah, so the first Citizen Assembly in Ireland, the Constitution Convention, had 1/3 politicians actually in the room. So this was something that we were extremely concerned about in terms of, professional politicians interacting with random citizens. We did a lot of research into it. Some of the slides that I kind of skipped over there in the interest of having more time for discussion were about that. So what we found was we had very strong norms agreed where people were to listen to each other with respect. They were to try to have an open mind. And every week we asked questions about, did you find that somebody had already made up their mind? Were people listening to you with respect? Were they trying to influence you outside of the table and so on? So we tried to keep a track of it like that. And actually we found that the politicians behaved really well and largely didn't do it and largely didn't dominate at the round table discussion. It was very different at plenary. So at the plenary discussion, when all the tables are talking, the TV cameras are on and it's live streamed. And of course, the politicians couldn't help themselves. When there's a TV camera on, politicians have to speak. So at those sessions, it didn't work so well. And at the most recent one in Dublin, there were politicians in the room again, and they were actually it was about how they were going to be elected and paid. And that just didn't work. They were in the room lobbying, and it just didn't work. So that's why we tried to keep the process to having a citizen assembly that then goes to a parliamentary committee so the politicians can then do it. But it's also really important about lobbying from outside. So one of the rules is that, if any interest group tries to lobby a citizen, then they're not allowed to present at the assembly. So it's made very clear to all the lobbyists and the interest groups in the area that any attempt, it's a bit like meddling with a juror in a jury case, any attempt to actually lobby a member will mean that you won't be allowed to present at all to the assembly. So that in Ireland anyway has managed to keep a lid on it. I know in other countries, some people say, oh, that wouldn't work here. But in my experience, most things where people say, oh, it wouldn't work in my country, when they actually try it, it often does.
Jane, how much did it have to do with you and David's reputation as independent scholars, academics, in pulling some of these off initially? Because you have to really demonstrate that whoever is leading it has no political leanings. They're looking for people's deliberation. And how did you manage that aspect of it?
Yeah, well, David and I we led the first experimental one where we demonstrated it. And that's where I was saying the person who was kind of up on stage talking was the director of the National Theatre, who was a great guy. And then the woman who was doing the leading the discussions with media and politicians was a former political editor of the national broadcaster who knew everybody. So that was the kind of team that we had for the first one to demonstrate that this could work. But then the government took it on themselves, but they made it an independent body. So the Citizen Assembly, the civil servants are seconded across to it to be independent. Now, David now thinks that they should be even more independent than they are. So there's a trade-off here. If you have there's still the people in the Secretariat are civil servants. They are seconded and they are independent, but some people would say, well, they should be more independent again. Whereas the political system here would say, no, the advantage of having them as seconded civil servants means they know how to lobby and get the findings of the Citizen Assembly into the system and accepted within the system and so on. Whereas if they were a totally independent NGO, it would be a very different situation. So there's kind of pros and cons to all of this. But we were lucky in that the first civil servant who was seconded was a person called Art O'Leary. He's been doing a lot of different talks and gone out and spoken to people. And he's a very independent-minded civil servant, so he was able to run it, and then we were able to advise him, and we used the kind of playbook, if you like, from our first experimental one. So we were lucky, as well as other things, you know what I mean, to demonstrate it and to be able to put it through. But I think now that it's worked and it's in so many other countries, that there isn't that same onus on a country just starting off with it, because you can point to the international examples now and so on of successful change. So I think it's kind of moving along a little bit over the last decade.
Yeah, I think the first one in a context like Armenia's would be a very delicate balancing act, making sure that it goes all right, otherwise it will never be used again. So. Okay, any other questions?
I don't know if Armenia looks to, my geopolitics aren't brilliant, but certainly Estonia has been doing some great work. So I don't know whether there, you know, it would be worth talking to on citizen assemblies on climate. So if that would help with anybody, I could easily put you in touch with the people in Estonia who've been doing it.
I've personally talked to some Estonian colleagues on this. The case of Estonia, of course, is that the Estonian president's office set up the citizen assembly. So that it was kind of a political choice to let the citizen assembly be the advisor, policy advisor to the politicians. And they stayed out of it. The condition was they would organize it and they would just simply get input from citizens. And that, something that should be exactly how it should be, because otherwise the citizen assemblies becomes this pure exercise in deliberation. That if that doesn't impact policymakers in any way, then people get discouraged. Yes, and it might be worth to talk more to the Estonian colleagues. Yes, Molly, and she's not Irish.
This is such an inspiring and informative gathering. I just wanted to say that there is or are international professional organizations of professional facilitators that could be engaged as consultants that would have that independent halo effect.
It's definitely something to look into.
Yeah, and there's organizations like FIDE, so the Federation of Innovation and Democracy in Europe, you know, which do a lot of work in this area, and others as well. So there's definitely a lot of help out there, should you.
There's going to be we're going to experiment with the citizen assemblies in March of this year on urban transport issues related to the Peritia project. The EU project is spearheading and we'll get a sense of the complexity of putting something this up. We don't have the same onus as the kinds of this is more of a game to do learn about trust in experts as opposed to really work out through a whole citizen assembly to get policy advice. But we'll get the process going and see how we'll do that. Okay, and your book with David, that small book that you showed earlier on, of course, is inspiration as well. Very good. Everyone, Sharon, a pleasure. And by the way, can I ask you, Sharon, in terms of your experience around the world working with different countries on constitutional reforms, do you find people are looking for citizen input, citizen assemblies? Because it's, if you leave it up to politicians, they'll do it behind closed doors.
Yeah, it's a great question. And, public participation in policy making and rulemaking, constitutional reform processes, I think is becoming understood as now a foundational aspect of democratic decision making. So in every in every reform process we've been involved in, there has always been a public participation element. Sometimes, you know, more successful than others. Sometimes actually the results and inputs are more reflected in the outcomes than others. When it comes to climate change, like Jane said earlier, citizens' assemblies, I think, are an interesting component because they give a double mandate to politicians to potentially push forward on popular policymaking and decisions. But I would caution that we cannot assume that anytime the public is involved in decisions related to climate change that we will have progressive outcomes. For example, in Switzerland, which is known as a bastion of direct democracy, at referendum last year, several constitutional protection measures were defeated. So I just caution, like, as has already been coming out in this discussion, that one can't always be assured that when you go to the public, the outcome will be progressive. However, citizens' input within these processes is now understood as a norm of constitution making.
Thank you very much. Okay.